Can a child really choose which parent to live with? A lot of parents think so. They've heard that once a child turns 12, they get to decide. End of story. But that's not what Texas law says. In fact, this misunderstanding can cause serious frustration in custody cases, and I'm the one who has to break the bad news. I'm Matthew Harris, a Texas board-certified family law attorney. So let's clear up children's choice once and for all by looking at what the law actually says, in my experience what judges really do, and how parents can avoid the biggest mistakes. Texas Family Code section 153.009 is where this rule comes from. Here's the key part. If a child is 12 years or older, the judge shall interview that child in private, in chambers, if one of the parents, the amicus attorney, or the attorney ad litem requests it. The word shall is important. Shall means must, as in the judge can't refuse. The interview isn't automatic though. Somebody has to ask for it. But if they do, the judge is required to hold it. Now, if the child is under 12, the judge may interview the child if requested, but doesn't have to. It's totally up to the judge. Also, even if nobody requests it, the judge can always make the decision themselves that they want this interview with any child, regardless of age. So, the real dividing line at age 12 is the right to an interview, not the right to choose. Even if the judge interviews the child, what the child says is never binding. The judge listens, asks questions, and weighs the answers. But the final decision still comes down to what's in the child's best interest. So, what does that interview actually look like? It usually takes place privately, in the judge's office, not in open court. The parents are not allowed in the room. The attorneys might be there, but that's up to the judge. The judge will have a conversation with the child, asking things like, who do you live with now? How do you feel about that arrangement? What's school like? If you could pick, where would you like to live and why? Now, the judges are trained to look beyond simple answers. They're paying attention to how mature the child seems, how consistent their reasoning is, and whether anyone has been coaching them. If a 12-year-old says, I want to live with dad because he lets me stay up all night, the judge takes note, but not in the way the parent might hope. If a 16-year-old calmly says, I feel more stable with mom because I get help with school and have fewer fights, that's a thoughtful opinion. It carries more weight, but it still doesn't control the outcome. The interview gives the child a voice, not a vote. Every custody decision in Texas comes down to one standard: what's in the best interest of the child. That idea comes from a Texas Supreme Court case called Holly v. Adams, which listed the non-exclusive factors that judges still use today. Those include the child's emotional and physical needs, each parent's ability to meet those needs, the stability of each home, future plans for the child, and yes, the child's own wishes. Notice that last one, the child's wishes, is only one of the factors. Even if the child is older and speaks clearly, the judge still has to balance that against everything else. And if the court suspects that a parent has influenced or pressured the child, that can seriously backfire. Judges are very sensitive to manipulation. They'll often say, I can tell when a child has been coached. One time, I even had a case where the judge said that child has been brainwashed. So, while the child's opinion matters, it's never the deciding factor. The focus stays on the child's safety, stability, and long-term well-being. Now, let's talk strategy, because this is where parents often go wrong. Mistake number one, telling the child they get to decide. That's false, and it creates massive emotional pressure. When the judge makes a different decision, the child feels like they failed someone. It is massively unfair to put that kind of pressure on the shoulders of a child. Mistake number two, coaching your child on what to say. Judges can hear it instantly. When a 12-year-old uses adult phrases like, I just feel like this arrangement would be more conducive to my emotional stability, it's obvious. If you put thoughts into your child's head, then are you really helping them by having them tell the judge what you want? Mistake number three, filing for custody only because your child said that they want to live with you. Children's feelings can change quickly. Sometimes after one punishment or argument, you need more than just their preference to win your case. I've seen more than a couple of cases where a parent spent thousands of dollars fighting for custody because that's what the child said they wanted, just for the child to change their mind right before the final hearing. So, what should you do? Listen, but don't make promises. Say something like, thank you for telling me. The judge will think about what's best for you, and I'll do my part to help them understand. Talk to your attorney about whether requesting an interview makes sense strategically. Sometimes it helps. Other times, it opens uncomfortable questions. Focus on stability. School, home life, health, and consistency. Judges love evidence of routine and support. And finally, if your child wants to live with you because the other parent is abusive or unsafe, tell your attorney immediately. That's when the judge may appoint a guardian ad litem or amicus attorney to protect the child's best interest. Even in those cases, the focus is on protection and safety, not on giving the child the power to choose. So, can a 12-year-old choose which parent to live with in Texas? No, but they can ask to be heard. If the child is 12 or older, the judge must interview them if someone requests it. If the child is under 12, the judge may interview them, but doesn't have to. Either way, the child's opinion is just one piece of the puzzle. The final decision always rests with what's in the child's best interest, not on who they like better this week. So remember, in Texas, a child gets a voice, not a choice. Before you go on to watch our previous video about how dads win custody, or our testimony tips, please like this video and subscribe so you don't miss our weekly videos or daily legal pop quizzes.